am Heather Panic, and I am a Senior ERISA Consultant at the Retirement Learning Center. Welcome to our regular segment on Case of the Week. This week's case relates to the Department of Labor's Abandoned Plan Program and the new changes for Chapter 7 bankruptcy trustees that were just made. As a reminder, these are real-life cases drawn from calls to our consultants on the resource desk from financial professionals all over the country. The Department of Labor's Abandoned Plan Program was implemented in 2006 and provides a process for the termination and distribution of benefits from an individual account retirement plan, such as a 401k plan or a 403b plan, in the situation where the plan sponsor has closed down and abandoned the plan. When a plan is abandoned, custodians such as banks, insurers, and mutual fund companies are often left holding assets with no authority to terminate the plan or make benefit decisions. This means that plan participants are unable to access the retirement benefits that they have earned. Under the Department of Labor's Abandoned Plan Program, custodians can wind up the affairs of abandoned plans so that benefits are able to be distributed to participants and beneficiaries. In general, a plan is abandoned if no contributions to or distributions from the plan have been made for a period of at least 12 consecutive months, and following reasonable efforts to locate the plan sponsor, it is determined that the sponsor no longer exists, cannot be located, or is unable to maintain the plan. The determination of whether a plan is abandoned can only be made by a qualified termination administrator, or a QTA. Examples of entities that could be classified as QTAs are banks, trust companies, or insurance companies. Once a plan is deemed abandoned by a QTA, regulations require that the QTA notify the Employee Benefit Security Administration before and after terminating and winding up a plan, locating and updating plan records, calculating benefits payable to participants and beneficiaries, notifying participants and beneficiaries of the termination of the plan, their rights, and their distribution options, distributing benefits to participants and beneficiaries, and filing a summary terminal report, which is not the same as a final 5500. A final 5500 does not have to be filed by the QTA. So what has changed? On May 16, 2024, the Employee Benefit Security Administration of the DOL published interim final rules and amended the Abandoned Plan Program to allow Chapter 7 bankruptcy trustees who are responsible for administering a bankrupt company's individual retirement plan to terminate and distribute benefits to participants under the Abandoned Plan Program. Prior to this change, Chapter 7 bankruptcy trustees were unable to use this program. There are special rules for Chapter 7 bankruptcy trustees. In cases where a plan sponsors in Chapter 7 bankruptcy, a plan is considered abandoned when a bankruptcy court enters an order for relief in the sponsor's Chapter 7 case. In these situations, the Chapter 7 bankruptcy trustee is the QTA. In these situations, the Chapter 7 bankruptcy trustee's duties are generally the same as the QTA's, but there are a few differences. The bankruptcy trustee must make reasonable and diligent efforts to determine whether the plan is owed any contributions, whether from employees or employees, and any amount that is owed. If the bankruptcy trustee determines that the delinquent contributions are greater than a de minimis amount, the bankruptcy trustee must appoint an eligible designee to terminate and wind up the plan. The eligible designee must make reasonable steps to collect all of the delinquent contributions on the plan's behalf. The bankruptcy trustee is responsible for selecting and monitoring the eligible designee in accordance with ERISA's fiduciary duties. The bankruptcy trustee must also report to the DOL any activity that the bankruptcy trustee believes may be evidence of a fiduciary breach involving plan assets by a prior plan fiduciary. The amendment is effective July 16, 2024, and may be relied upon by Chapter 7 bankruptcy trustees after that date. The EBSA also amended the Prohibited Transaction Exemption, PTE 2006-06, to permit Chapter 7 bankruptcy trustees who are using the Abandoned Plan Program to be able to pay themselves for their services rendered in furtherance of terminating and distributing benefits under the program. As a financial advisor who works with plan sponsors, investors, or plan participants, you can play a pivotal role in helping them with cases such as this. If you are looking for more of an in-depth written version of this case, you can find it on our website, retirementlc.com. Thank you.